My name is Joseph McDaniel, and I'm an Arizona bankruptcy attorney. And since 2005, I also get to tell you that I'm a debt relief agency, and I help people and businesses file for bankruptcy, as I have for about 30 years. Today, we're going to talk about my 100% Arizona bankruptcy guarantee. Every now and then, I'll see some bankruptcy lawyer in Cleveland or Denver offering a money-back guarantee about something that's pretty straightforward. For instance, you'll see a guarantee that if the case is dismissed for failure to pass the means test after the debtor has provided accurate information to the bankruptcy lawyer, there will be a refund of the fee paid for the bankruptcy. Now, that's a pretty safe bet, because if a debtor tells me the numbers and they go through the sophisticated software in my office, there's a very darn good chance that the Chapter 7 cases I file will pass the means test. Because to a large extent, that's just a matter of number crunching, although there is a bit more to it than that. And I am not, repeat, ain't gonna file a case if it ain't gonna pass the means test. Just won't. I know what comes after that. Or a lawyer might guarantee that somebody will show up to represent you at your first meeting of creditors. Well, duh. Or a lawyer will guarantee that if you have been straight with him in filling out the forms and you don't get a discharge, you'll get your money back. See, I have my own guarantee, and I make it boldly and without fear for anybody to hear. I guarantee that I will file your case on a day ending in Y, if you pass the means test, of course, and otherwise, I won't. There, I said it, and I'm not afraid to say it. I also guarantee, if pressed, that the sky is blue and the grass is green, but only under great duress. Because if a lawyer offers a guarantee, there are only two possible reasons he's doing it. One is that he wants more business, and he wants to make the process seem less risky. Hey, would I guarantee a result if I were worried about the outcome? Or the lawyer is simply limiting the scope of the guarantee to items so unlikely to occur that it's a sucker bet to bet against him. I personally just don't like guarantees. I think they set up an adverse relationship between the lawyer and the client. And frankly, a money-back guarantee doesn't begin to cover the issues if something goes seriously wrong in a bankruptcy case in Arizona. What could possibly go wrong? Well, the debtor could fail by mistake or by way of forgetfulness that he owns property in Mexico. Now, could that happen? Yeah, like on Wednesday, you know? So what to do to minimize the issue? Well, the bankruptcy lawyer would amend quick like a bunny and hold his breath until he turns blue, hoping that the silly debtor doesn't get himself squashed like a bug. Or a debtor might decide not to list a creditor, or an attorney for a trustee might object to an exemption that's clearly legit, but the client can't handle any risk whatsoever that the trustee could prevail. Note, in this context, it's better to be lucky than smart. Or a debtor might decide not to schedule that he sold his Corvette to his sister for $1 the day prior to the bankruptcy filing. Again, duh. Or a debtor might have previously lied like a doggy to get a line of credit, and he might get caught by the bank prior to the entry of the discharge. Or the debtor, against written instruction from counsel, might rack up huge credit card debt inside the 90-day period or on the 91st day, because that looks really good, right? The list of what can go wrong goes on and on for about 30 years so far, in my experience. So what do you do as a lawyer with guarantees? Well, I just don't make them. I've seen too much, and there are too many ways for something to go sideways in a bankruptcy court after the 2005 amendments. And if something goes sideways, what does a good Arizona bankruptcy attorney do? Well, he does whatever he can to minimize the bleeding, you know? One thing that can go sideways in a Chapter 7 case, for instance, is that a creditor can file a complaint to determine dischargeability of a debt. That requires additional work, and it's litigation. Or, as I cheerfully tell my clients, if I got to jump in front of a bus for you, that'll cost extra. When I wanted to get my eyes sliced and diced with a laser to correct my nearsightedness, I knew darn well I wasn't going to get a guarantee out of a board-certified eye surgeon. So I did research into credentials and experience and training and testimonials like a crazed weasel. When you decide that you're going to file a bankruptcy, you might want to research credentials and experience and training and testimonials the same way. But only if your discharge is important to you, you know? Or you can get a guarantee. Your choice. Thank you very much.